Thanks, Sam, and welcome, everyone. Today we're going to be talking about account titling, ownership, and signatories, and all of those kind of common things that go wrong when you open new accounts, and especially in these days when the signature cards seem to be getting longer and longer and more complicated. I think you saw on slide 2 that there will be state law issues that will come up in your state, and on our website we have provided those links to your state law, so you can go under resources. All of that is free, and you just click on your link, and then you can go to your power of attorney statute or to your particular banking statutes that might apply in these issues. So we're going to be focusing on today things that we all share, these themes about trying to particularly come to some kind of consistency about the way that we're going to title accounts, how they're owned, and how we're going to have them signed on our signature card contracts, because we want to stay out of that kind of dark hole where each branch does what they want to do, and we end up with all kinds of inconsistencies. So before our 2-hour journey is over today, what I hope to do is set up through these slides a series of checklists and frameworks for you to be operating in. Then you could slide in your sample signature cards and maybe a couple of state law issues that might apply in your state. And then what you'll have before you're done with very little work will be that new account procedure manual you've been waiting on and dreaming of all these years. So we're going to move through this and begin talking about the first one, which is always somewhat the easiest one, although sometimes you wonder that a single party account where one person is the owner and one person is the signer, and we'll check off that box single party. Some states still call them individual accounts. Some states call them single-party accounts, and really it's just tomato. But what we're going to be doing when we open accounts always is setting it in that federal context. So you're going to be getting their name, address, date of birth, tax ID number on the owner of the account, and then, of course, their Social Security number, and then documentary requirements always vary a little bit from financial institution to financial institution. Some of you might get one form of ID. Some of you might get 2 forms of ID, but whatever that is, you want to be consistent about the application of that process. So again, as we look to these and we're talking about these, remember you're going to also do some non-document verification and then style it with their name. Just some issues that come up with the IRS and account styling. Remember, the IRS, as far as interest-bearing accounts, will read the first 4 letters of the last name. They're not so much interested in is it J. Smith or J.R. Smith or how they spell John. They're really more interested in the fact that this account is going to have to match a name control file at the IRS, and SMIT is what they're interested in matching. There is an e-service that's available at irs.gov under their e-services. It's called 10Match, and you can actually enter names for free, and it'll tell you whether or not it matches that tax identification number. But if you do choose to use that service, remember somebody from your financial institution is going to have to register, and there's a verification process that goes through, and it's kind of a lengthy question and answer process. But you're to use that service to match tax ID numbers for 1099 INT reporting. So that has to be your purpose when you're using it. You can't be using it for other purposes. So just kind of to give you the heads up on that. Now, what I see go right and wrong a lot of times with single-party accounts, individual accounts, whatever you call them in your particular state, is that we don't get it clean. In other words, we check off individual or single party, we title it John Smith, and then John Smith signs. That's what I call the Bermuda Triangle. So as long as that's the way it's set up, then it's going to work beautifully. But I just saw a signature card that was pretty dated, and it said single party account or individual account, and then it had little Johnny at the top, and it was a child, John Smith, and at the bottom it had Grandma, and Grandma signed for Grandpa, and Grandma signed for little Johnny. So, yeah, indeed, it might be a single-party account, but is it Grandma's single-party account or is it the child's single-party account? And this is where any time that you create lack of clarity in your account cards, in your stylings, and in your system, that you can leave room for error and litigation. And so what happens then is this card, the estate is challenging that this money belongs to Grandma. And so the card has now been, turned over to the attorneys, and there's going to be a lawsuit involved in this, or a settling of a lawsuit. Where those practices from the old days, where we would set up these kind of whatever the account holder wants, we did it because the cards were 3x5 cards, and they were little tiny signature cards back 30 years ago. But again, here today, when you're talking single party or individual account, there should only be one party involved in this. And I see people using single party and individual accounts for things like Social Security rep payees. Well, in my estimation, that's not a single party account because there's two parties, the person that it's for and the person who owns it. And so, again, as we come into this discussion, you have to be careful about doing things just for FDIC purposes. Some people do things just for insurance purposes. Well, it's insured as a single party, so it's a single party. Well, yeah, but how is it owned? And that needs to sync up. And the FDIC knows Social Security Representative Payee account is owned by the rep payee. So I just want to challenge you to be, again, we can argue about some of these things, and we probably will, as the day goes by, but the deal is whatever you decide and however you decide to open up account, you want to open it that way 1,000 times, and you want to really be consistent about what is an individual and what is a single party account and what is not. So these are the kind of things that I see where, yeah, it says single party at the top of the card, but at the bottom of the card you had three signers, Grandma, Grandpa, and Grandma for little Johnny, whatever that meant. And so, again, these kind of old practices coming back and haunting us in this new age time. And we're living with the things we did lots and lots of years ago, which is not fun because, again, lots and lots of years ago, that's the way we set them up, and things were a lot easier then. So, again, we're going to see as we go through kind of giving you some common errors, some things that I see when I set up signature cards, and I work with people on new accounts manuals. And, again, what happens is sometimes as an outsider, we can just see it so much clearer than someone who's actually involved in it on a day-to-day basis. And I don't mean that in the wrong way. You can do that in your own internal organization. It's like you set up the procedures and let somebody else look at them. And that outside perspective would be like, why'd you do that? Or what were you thinking when you did that? And it helps you get those signature card rights. I really like to see sample signature cards accompanying these checklists. Go in and tailor the checklist. What do the new account people have to get at your financial institution? And then also sample signature cards so they can see what the system needs to look like. If you want somebody to sign on a single-party account or an individual account, most states that I've ever worked in always have something like an agent, a power of attorney on the signature card, a convenient signer, an authorized signer I see in some states. So whatever this person is that's named and described in the signature card contract, and that's how John gets a signer on the account, is he can put someone to sign on his behalf, make transactions for him. Again, where the errors come in with this is understanding that they typically don't close accounts. They typically only do transactions for the benefit of John, that they should not be ACHing their own payroll check into this account. And so those are the kind of little things like, what? No. I mean, I saw one, it was crazy. It had John Smith, and it was pay on death to his mother and his brother. Well, it was a real tragedy. I mean, he passed away. He was killed in a car wreck. And his mother was having her payroll check ACH'd into this account. And so here you go again with ACH coming in from the mom. This account is over. It should have been shut down. And now basically those funds are owned jointly by the two POD beneficiaries, which was her son. And it actually had a happy ending to that story because, not happy as far as losing her son, but happy as far as the funds were concerned, because I was there that